Hello again, it's Nicole Sommer here. I'm here this week to help you take you through projects of state significance, which is a Tasmanian major projects assessment process, and the Australian EPBC Act National Environmental Law process. This is going to hopefully help you looking at the cable car and the types of assessments that might be required other than the ones that you already know about. So I'm going to take you through both the projects of state significance process, which is a Tasmanian state government piece of legislation, the process and its benefits and drawbacks for both the developer and the public. And then I'll take you through the Environment Protection and Biodiversity Conservation Act, which everyone calls the EPBC Act. And we'll go through when it's triggered, when the approval is required, and what the assessment process is. Starting with projects of state significance, this is a quick outline of the approvals process for a project of state significance. I'm not going to take you through it now, but this will hopefully synthesise what I'm going to take you through in the next few slides. So, when is a development a project of state significance? Well, a project is declared to be a project of state significance by the state government. It's declared under the State Policies and Projects Act 1993, which is a Tasmanian piece of legislation. The Premier is responsible for this piece of legislation and for any project of state significance. To be declared, it has to meet the test of state significance. Now that test is set out here on the slide. The project must possess two or more of the following. So from A to G, significant capital investment, significant contributions to the state's economic development, and it continues. So for the cable car, think about what tests it might meet. It probably doesn't have D. It doesn't have a significant potential contribution to Australia's balance of payments, so that means national economic significance. But it very well could meet probably A, significant capital investment, and F, complex technical processes and engineering designs. There might be others that you might think about, and just have a think about whether it is even in the ballpark of being a project of state significance. So the first stage is project declaration. Who declares the project to be of state significance? Well, it's a position called the Governor in Council on the Premier's recommendation. The Governor in Council really just means the Governor signs an order. The Premier is the real decision maker here. So by convention, the Governor of Tasmania will always adopt the Premier's recommendation. If the Governor in Council makes an order, it then goes to both houses of the Tasmanian Parliament and must be approved by both houses. So if so there's two houses of Parliament. If the upper house or the lower house doesn't agree that it's a project of state significance, they can overturn that decision. And it goes back to the normal assessment process. Now, once a project is declared, all other legislation ceases to apply. So you don't need your EPA approval, you don't need your council approval, you just need the approval under the State Policies and Projects Act. The Premier then has complete control over this process. So the Premier directs the Tasmanian Planning Commission to undertake an integrated impact assessment of the project and can direct the Commission on its content, process and timeframes for assessment. Very importantly, it can also direct the Commission to dispense with public notification, meaning that the Commission just assesses the project without calling for representations from members of the public and without any public hearings. The project assessment process is relatively complex. The Commission has to prepare what are called integrated impact statement guidelines. That is pretty much the same as the EPA's guidelines that it issues for a level 2 project. They have to be publicly exhibited, and then the Commission makes any changes and prepares the final guidelines. And then the proponent has to prepare its impact statement, which is called an integrated impact statement. It's basically an environmental impact statement. The Commission, once it receives that impact statement, gives notice to various agencies. There's another form of notice, and there's public hearings. The Commission prepares what's called a draft integrated assessment report. That also is publicly exhibited, and there's representations and possibly hearings. And then the Commission prepares a final report to the Premier on whether the project should be approved. So that process is probably a lengthy process with notice and hearings on both the impact statement and on the Commission's own report. Once the Commission finalises its report, it provides it to the Premier with recommendations on whether the project should be approved and includes conditions that should be applied to that approval. The Premier then considers that report and makes his own decision on whether to approve or refuse the project, making that recommendation again to the Governor and Council. This is quite important, if there's an approval recommended, that approval will include every permit, approval or licence that is required for the project and the conditions of those approvals. So if a project required a planning permit, if it required assessment by the EPA, if it required a threatened species permit, an Aboriginal heritage permit, all of those permits and approvals are given in this one approval from the Premier. That is a real benefit to a developer in this process because it's what's called an integrated approvals process. Now, the Premier can also vary the Commission's recommendation. So the Commission might say the project shouldn't be approved, and the Premier can say, I don't agree, I think the project should be approved. Or the Commission might have different views on conditions and the like. So he's not bound by the Commission's recommendation. So then, let's say the Premier approves the project, the Governor and Council makes that order, and that order is then again put before both houses of the Tasmanian Parliament. And they can disallow the approval given by the Premier. The benefits of this process for the developer are there's quite a few benefits. The principal one is it's an integrated approvals process. It's what's called, and you'll often hear this referred to, a one-stop shop for approvals. So the Premier gives all of the approvals for this project in one go. That's a really big benefit for any developer. The Premier can dispense with public notice and therefore hearings, and the Premier can also direct assessment to be within a specified time frame, so it gives you greater certainty about timing. The Commission is not required to hold hearings, and the removal of notice and hearings is probably a big benefit for a developer because it will speed up timeframes and it will decrease scrutiny. Then there's no third-party appeal rights to the tribunal, so you can't take legal challenge to the tribunal. The benefits also accrue to the public, however. It's not all one way. This process is an integrated assessment process, which means that you have to consider all of the impacts together and in full. So if a project is not an EPA assessed level 2 project, think about what approval would be required from the council and whether that's a complete environmental impact assessment. This, however, is a complete environmental impact assessment. Now, also beneficial is that there's probably a public hearing process before the Commission. There's also parliamentary oversight. So these give a member of the public the potential capacity to influence an outcome. There's a number of drawbacks as well. So think about drawbacks for the developer. That parliamentary oversight means that there has to be some political reasons why you would want to approve a project, or why you would want the project to go through this process. That creates uncertainty, and in practice will be a reason why the Premier will not dispense with public notice. It also may not be a quicker process than the EPA assessment because of that. If you have public hearings on 3 separate occasions, or 2 separate occasions I should say, that's quite a long process. The drawbacks of the public are fairly evident. Premier controls the process. There's the potential for no notice or public hearings, and there's no merits review if the decision is adverse. So then your only options for legal challenge are restricted to the Supreme Court, which can be costly. Now, just giving you here a brief outline of the key elements. That's just to help you when you're going back over this later, so I won't go through it. So, moving then to the EPBC Act. The EPBC Act is a very significant piece of legislation. It is the only national law regulating environmental matters. And states historically have had full responsibility for environmental impacts, and they continue to do so if the EPBC Act is not triggered. Now, it's not always triggered. It only regulates matters of national environmental significance, and they are listed in the Act. We'll go through what they are. That's because it gives effect to international conventions around the environment, so they're international conventions, and they're really only very significant in environmental matters. Just for some history, this is really not something you need to know, but the reason why we have this piece of legislation is because of a Tasmanian case, the Tasmanian Dams case, where the Tasmanian state government wanted to dam the Franklin River for hydroelectricity, and the national government stepped in and stopped them from doing it, bowing to political pressure. And the state government challenged that in the High Court, and the Tasmanian state government lost. They said the Australian government cannot regulate environmental matters because of the Constitution, and the High Court found that the Australian government can because of its external affairs power. Now, that's really the reason why the EPBC Act is limited to international conventions, giving effect to international conventions. You don't need to know that, but it's just some interesting history. The EPBC Act, if it's triggered, this is a very, very brief outline of the approvals process. First, there is a referral by the developer or an authority with an approval role to the Commonwealth Minister for the Environment. The question that is asked at that stage is, will the proposed action or development cause a significant impact on a matter of national environmental significance? So there's a referral. If the answer to that question is yes, then it's assessed by the Australian Minister for Environment. The methods for assessment are set out under Part 8. Then the Minister for Environment decides whether to approve or refuse the proposed action and whether to impose conditions under Part 9. So 3 steps: referral, assessment, approval. We're going to go through those steps now. First question is the difficult question of when approval is required. It is not required all the time. Be very aware. The EPBC Act prohibits any person from taking an action, we'll get to that definition, that has, will have, or is likely to have a significant impact on a matter of national environmental significance without approval under Part 9 of the EPBC Act. So, for instance, this is one of the sections, Section 12 for World Heritage properties, makes it an offence for a person to take an action that has or will have a significant impact on the World Heritage values of a declared World Heritage property. And you can see there's significant penalties there. So 5,000 penalty units is probably around $100,000. An action is, so what is an action? An action is effectively any development. Anything that's a development will be an action. That's the definition, but that's the way to think about it. So any development may be an action that requires approval. As I said, the EPBC Act does not apply in all cases. These are the questions that you should ask yourself. And I think it's a really helpful way of guiding yourself through the does this need a referral question. Firstly, are there matters of national environmental significance in the area of the proposed action? So go and find out if there's any matters of national environmental significance there. Really easy if there's something like a Ramsar wetland or if it's a development in the Tasmanian Wilderness World Heritage Area, but less easy for threatened species and ecological communities. So that also includes any matters that are adjacent to or downstream from the proposed development site that may be impacted. It's a broad test. Then the second question, is there a potential for impact on any of those matters, whether it's direct or indirect? The third question is, are any of those impacts a significant impact? Now, that's the critical test. Whether there is a significant impact is actually the question that you need to ask. That's the key question. The fourth is, are there any proposed measures to avoid or reduce impacts on matters of national environmental significance to below the significant impact test? Don't focus on this too much, but just be aware of it. The first step really is the key, was the first key step. So are there any matters of national environmental significance in the area? These are this is the list of matters of national environmental significance in its categories. So go through that list and think about those things. Just to help you in Tasmanian context, a World Heritage property includes the Port Arthur Historic Site for its social and cultural values, and the Tasmanian Wilderness World Heritage Area for its ecological and wilderness and cultural values. Also, there are other places like those places that are listed. So declared Ramsar wetlands, like Malting Lagoon near Freycinet is one of them. And then there's a range of threatened species and ecological communities that are listed. This is the one that normally triggers an assessment, or at least triggers you thinking about whether assessment is required. So I've put here a range of threatened species that are found in Wellington Park: the Tasmanian devil, the swift parrot, the Kettering drumstick heath, and the dainty leek orchid and bottom white. There's only a few ecological communities listed under the EPBC Act. One of them is alpine sphagnum bogs and associated fens, which are found throughout the Tasmanian high country. Now, the best way to find out whether there's something is a matter of national environmental significance is simply to go to the EPBC Act website on the Australian Environment Department's website. It's a really good resource, and that's the best way to find out. You'll come to know what some of them are, but you really, that's the best starting point. So I've given you the link there. Be aware that only those things that are listed or declared are matters of national environmental significance. So there's always going to be a list that you can go to. You don't need to try and work it out through some other means. Some matters are listed by international bodies under international conventions, like the Ramsar Convention for Ramsar wetlands. I've given you a list there just to help those who are interested. And some matters are listed by the Australian government. So, for instance, threatened species and communities are listed through a nomination process which goes to a scientific committee review, so that that gives effect to the Convention on Biological Diversity by protecting important threatened species and communities. The next step is to ask whether there's an impact at all on matters of national environmental significance. Now, that impact can be direct or indirect. So a direct impact will be an impact where you're clearing vegetation that is a threatened species which is listed or part of an ecological community. So you're physically removing the thing that is listed. An indirect impact will be clearing trees which provide habitat for a listed species. So you're not physically hurting the swift parrot itself, but you are removing habitat that it relies upon to survive. So that is an indirect impact. The key question here is whether that impact is significant. Now, the best guidance to assist you with this is in the Department of Environment's Significant Impact Guidelines, and I've given you the link. Anyone who's looking at this should read those guidelines, or at least be familiar enough with them to understand what significant means to the Australian Department of Environment. An impact will be significant when the impact is important, notable, or of consequence, having regard to its context or intensity, that is, the context or intensity of the action. So removing one tree that provides habitat to a swift parrot is not going to be significant. There's a question about when that threshold might be reached. So removing some hectares may also not be significant, but there's a question about that. To help guide you through this, those significant impact guidelines provide significant impact criteria for each class of MNES. So go and have a look at those criteria, and then you'll be able to see that it's more than minor. So I'll just take you through one quickly. So for a critically endangered species like the swift parrot, it's only going to be where the action will lead to a long-term decrease in the size of the population or reduce the area of occupancy for the species. So you can see that these are questions for experts in these areas, but that significant impact criteria is a good guide. So the fourth step here then is to look at whether there's measures to avoid or reduce impacts to below the significant impact threshold. Really murky test. I don't encourage you to dwell on it too much, but it includes avoidance of a threatened species. So think about the cable car. If the cable car is going through swift parrot habitat, or there's swift parrot habitat nearby, and actually the path of the cable car avoids that habitat, that might be something that you think about in terms of whether the impact is significant. I've given you some more guidance there about swift parrot. When you're thinking about impacts or the potential impacts, go to the EPBC Act Conservation Advice of the Threatened Species Scientific Committee and any National Recovery Plan. Again, you can find all of that information on the Department of Environment's website. It's a really good resource. So let's assume that we've decided that there is likely to be a significant impact on a matter of national environmental significance. The next step is referral. Now that's where we started at the beginning. So we refer the action to the Commonwealth Environment Minister. It's always called an EPBC Act referral. The Minister has to publicly exhibit every referral and all the documents provided to him. In fact, her now, as of last week. And I've given you a link there so that you can go and have a look and see the sorts of things that are included in a referral and the sorts of actions that are referred. So the Minister will then decide whether the action is what's called a controlled action. A controlled action just means one that requires approval under Part 9 of the EPBC Act. If it is a controlled action, the Minister will then decide the assessment method. The Minister will receive an assessment report, I say from a state agency, I'll tell you why in a second, and the Minister then makes a decision, having regard to that report, to refuse or to approve with conditions. I will say that usually projects are approved with conditions. There's very few over since 1999 which have been refused. So the assessment method is the one thing I wanted to touch on. Be very aware that the Australian government does not assess the environmental impacts itself. It relies wholly on a state environmental impact assessment process. So don't think that the Commonwealth or the Australian government is going to say there has to be a form of assessment under the EPBC Act. It will be a state assessment process. And think about the projects of state significance. The Tasmanian Planning Commission prepares a report which goes to the State Minister. That very same report is the report that goes to the Commonwealth Minister if an EPBC Act approval is required. The reason why all assessments is under state law is because there is what's called a bilateral assessments agreement between the Tasmanian government and the Australian government, and it accredits state legislation and state environmental impact assessment processes for the purposes of the EPBC Act. They used to do what's called case-by-case accreditation, but they now solely rely on the bilateral assessments agreement. So there's only a few assessments that are accredited. The Level 2 assessment in Tasmania, Level 2 assessment by the EPA, projects of state significance, and projects of regional significance. If there was a different major projects legislation, presumably you'd see that accredited as well. Be very clear that the normal permit application process, assessment by the council, is not an accredited process and won't be, because it won't provide that full level of assessment of matters of national environmental significance that's required. So if EPBC Act approval is required, the applicant will want to use an accredited assessment process, which is why projects of state significance becomes important in the context of something like the cable car. So I hope that was helpful as an overview, and I hope that I can answer any questions in class. Thank you.